issue with it like this
Recording
before,
started.
so hey everybody, I want to welcome you to this week's Matrexit discussion group call for tactical sovereignty. We're about an hour late, but we're here either way, and we are with Elle, and we are doing part 2 on equity in the law, and it'll be star 2 if somebody wants to raise their hand on something, and we'll start Q&A up here in just several minutes. But what do you have that you wanted to open up with this evening, Al?
I just want, first of all, I'd like to thank you, Brian, for the 6 years of having incredible guests. I feel very honored to be here. I'm going to give thanks to the Creator and all my friends and other people who showed up to support us. I'm glad to hear that, you know, we're getting into the difference between law and equity, because like John Bouvier said, and I'm being redundant here, that the law is nothing without equity, and equity is everything even without the law. But equity is the soul and the spirit of the law, and it's based on honesty and truth and consciousness.
Yeah, and you know, like we talked about last week, going over a definition of what equity is really about. And so many people, I hear people come on court and they're like, oh, this was right or that was wrong, or they don't understand the morality of the courts and how they view morality, because it's not the same way as how we view it. They're looking at things, like I said before, more from the standpoint of legal or illegal, and not a right or wrong type of morality stance. And so really what equity does is looks at fairness. And I guess we also have to realize the courts kind of want to do what's fair for them as well. You know, what's fair in our eyes might not be fair in everybody else's eyes. But that's what equity is supposed to resolve.
I completely agree. In fact, there are 20 equity maxims. Some people say 19, but there are 20 that are the foundation of the whole jurisprudence of equity. And one of them is that equity follows the law. And so just listening to those words, you would think that it comes after the law, but literally it will come in, and sometimes over the same subject matter, the same rights, they actually have completely different ways of adjudicating the pleadings that are brought before them. And so it cleans up, and it offers, because it used to be in the common law that it was like we talked about last week, where it's like, well, we have all these remedies over here, and if you have a right over here that doesn't fit with our form over here, well, then you're screwed. And so equity comes in, and it fills in that gap there, so that the remedy is based on the right, not the right based on the remedy.
Correct. And one of the things I've looked at really with equity as well is because essentially the courts are following their statutes that have been laid out. What is supposed to happen in a certain situation? And it's also going to follow other treaties, for instance, that have been written and court decisions, which is part of common law. And that's really what the courts are following. But when you're bringing in equity, the way I've seen it is you're kind of setting the statutes aside, the statutory decisions aside. Would you agree with that?
Yeah, actually, so the maxims don't need to be proven. And so the judge is bound by the equity maxims based on, because the matters that have come before on the whole, like, for example, the clean hands doctrine, right? Like, you have to have clean hands. You can't be guilty if you're trying to bring a suit against someone. And so those have been adjudicated so much that they don't even need to be proven. They are just accepted as proof. And in fact, there's different kinds of equity, right? So there's statutory equity, it's concurrent, exclusive or inherent, auxiliary, and concurrent. And so I think that really for people, for our Creator-given rights, you know, that sticking with maxims and not using the statutory codes and stuff, because we're talking about the equity maxims are biblical. They come out of the Bible. And the Bible is a jurisprudence of law in the way with family, society, food, ourselves, our Creator, and how to create a harmonious system. So typically they would be like the Messiah. He said, "Have you not read in the Bible, in the scriptures? And doesn't your own laws read this?" So he didn't mix the two. He knew what the highest jurisdiction was.
One of my fears that I've had, for instance, people saying that they want to come from a point of equity, which there are quite a number actually of actions that the courts take that are done equitably. Yeah, equity. I read that list last week. To include, like you said, fair hands or injunction or even protective orders or suit and partition are various forms of equitable actions. But one of the things that I kind of look at a lot of times is that if we are wanting the court just to look at things from equity, you're kind of giving more of a free hand to the judicial administrator, where he's not going to be necessarily bound to the statutes, as far as say what a mandatory minimum is or a mandatory maximum is. So you're kind of putting yourself in a precarious position where, if this judicial administrator, their spouse got drunk the night before, beat the crap out of them, and they slept in the car all night, and here they roll into court, they're not going to be in the best mood. And I'm not really sure if in that state of mind you would want somebody ruling from an equitable standpoint. You understand what I'm saying?
Well, kind of, but see, that's the importance of maxims. So, like, say someone's bringing a suit against you, or a suit or a case, right? A bill or a case. The party next to you who's moving against you, right? They have their own conscience, okay? But the judges, the real judges, particularly like real equity, like chancellors and stuff, they are actually bound by the maxims. They have to adjudicate on that. They can't. They don't have. This isn't a discretionary trust. But I think one of the things, there was a guy, Cite Your Authority, this guy Eric. I learned a lot from him. I did not, because I hadn't learned anything about courts and motions or petitions or bills or anything, right? And I didn't realize that the person, whether it's a magistrate sitting there or a commissioner or a chancellor or a judge, that they adjudicate based on the law form that's brought in front of them. They're not sitting over here with all the laws. It's like, no, you're making a claim. Where do you get the right to make this claim, and why should I give you what you're asking for? And that's where you get into the memorandums that you write with the law, whatever it might be, And so, most of the statutory courts, because they are adjudicated, basically, it's a discretionary trust. And in discretionary trust, the trustees can determine, they have the right to determine who the beneficiary, what they're going to do, and which beneficiary. It's not fixed.
Right, and those things really are going to start out in the beginning from a statutory point of view. Even if people they say, "Oh, I've submitted motions to the court," and I've heard judges tell people, "Well, how did you do it? Did you follow the court rules?" And even every state's going to have their rules as to how things get filed, right down even to a particular court. A particular courtroom, that judge is even going to have his own set of rules, things that he follows, and it's recommended that people go and pull those out and find out what the adversary or whoever is using, what they observe, what they don't observe. And I've seen several times, even when they are forced to uphold something, maxim or whatever, where they're confronted with it 3 times. And then that 3rd time, I've even seen them get up and leave the bench, go back into the holiest of holies, back to their chambers. And I think they phone a friend or whatever, and then they come back out and they change their standpoint. Okay, we're going to honor this one today. You know what I mean? Yeah.
Yeah, and I think that's probably people not doing it right, because, like, for example, motions are for corporations, and I think that really, depending on how someone addresses it, if they're going to try to get an appointment through the clerk or whatever, that it really has to do with what equities, quote unquote, are on the face of the pleading. And a treatise on suits and chancery lays out the children, and like, for example, private trust. Private trust can only be adjudicated, not statutory trust, but private trust can only be adjudicated in exclusive equity. So there has the cause of action, the reason why someone is bringing a suit, whether it's a bill or a petition or whatever relief that they're seeking. And that's one of the interesting things too, now that I brought that up, I want to just expound on that, you know, reading the Bible, you know, it talks so much about prayers, right? And we're talking about the creator of the universe with righteous laws, who has his actual, you know, privy council still here today. I was always like, I pray from my heart, you know, I cry out. But when we're talking about actual court, whichever venue it is, one of the elements of that is a prayer for relief. And so it just depends on what kind of prayer and who it's being sent to, and on the kind of relief that can be granted. Because, you know, Boris and Lex and those guys, you know, they just love the fact that it's always like failure to state a claim for which relief can be granted. Because if someone's bringing in a trying to have their rights enforced, and the court doesn't have the power to adjudicate on that matter, well, I mean, you didn't state a claim. There's no relief that can be given in this venue here. We don't have the power to do that. And so I think it's important first of all, to just come to terms with what rights are, where they come from, and to actually cite your authority, you know, like in the jurisprudence of this is what a right is. So if someone's going to use the Bible and say, look, I have the right of ingress and egress right here, it says it right here. Or if it says, you know, in the Department of Transportation Code, whatever, you know, I think it's important to cite that, so that whenever who's adjudicating, sitting there on making the determination, that they know the law form that is being brought for them, and if they have the ability, because if not, you know, you can, like, for example, statutory courts, are they able to deal with religious issues? You know, is that something that they have the right to adjudicate on?
Well,
that's very important.
I think that's one of the things that people don't pay enough attention to, because average Joe is just going to think that, you know, when they're going into court, every court's just like any other court. And like you brought up, Rule B-12, you know, is as far as being able to provide relief. Mm-hmm. And so people, you got to go and look at those rules depending on what your situation is. You know, do you need to be looking at the civil rules of criminal procedure? I mean, what exactly is this act that they're coming forward with you at, and realize what things they're bound to and what things they're not. And I think most of the time, a lot of reasons why a lot of people fail is because they might try to use something from a civil matter in a criminal situation, or vice versa. And they don't comprehend these nuances about that. And they actually, earlier, before the recording, you were bringing up Dr. Graves. And Dr. Graves' class is very good at breaking all that down for people as well. So, yeah, that's something that would be recommended to people. But I got ultimately, you don't want to be spending your life fighting in court.
Well, yeah. Well, Dr. Graves is phenomenal at helping to teach at least for me, and teaching the ideas of what a cause of action is, what are the essential elements of a cause of action, what is admissible evidence, but that's statutory. That's like for corporations, and that was the venue. He was a lawyer for 36 years, and that's where most people do most of the court battle. You know, it says in the Bible that the path to hell is wide, the gate is wide, right? Broad and wide. But the way to life is narrow and small, and few will find it. And what's interesting is reading the when I first started reading about equity, it's like the king is the fountain of justice for his people, right? Well,
Right.
who's your king? What law is he adjudicating? And who's the priest or the judge, if you will, or the chancellor or the praetor? Or they've gone by many different names, commissioner,
Magi Street.
the magistrates, magistrate, those two, And that's all interesting because really the court systems, if you look back, when I was going through Deuteronomy, doing an intensive study, it's like all laid out right there, how they set it up. It's just that, what's happened through time is that, in a Hosea, it says, my people die for a lack of knowledge. Everyone knows that part. But the rest of that actual verse says, of my ways. You rejected the wisdom of being my priest, so I'm going to reject you. Well, what were the priests doing there? They were adjudicating the laws that were given by Ahiah, Asher, Ahiah, the righteous laws, not the state laws, not the IRS codes and all those other crazy statutes. So, I just hope people can, kind of comporting, to take what equity is in the different, because there's different kinds of equity.
Well, at this point, I'd say if anybody wants to interject with a question or something, try and keep it somewhat brief if you can. And you said it's *2 to raise your hand if you are on the phone. And if you're on the computer, you can just go to the board that shows participants, and you can raise your hand from that point as well. And we'll try and bring you in. They had an 804. I think had their hand raised. I don't know how long. Maybe accidentally from the beginning. I don't know.
I wonder if that's me still.
Are you an 804? No, you're a 970.
Yeah. Well, I'm not, but the phone is.
I'll just go to, not 804, 304. I'll go to 304 and unmute them briefly if they had something that they wanted to offer. 304 is unmuted.
The only thing I was going to say, Brian, is I didn't realize that you were having a problem with the first hour of the call, but usually your calls are well organized, and I was expecting to hear, based on the prior call from a couple of weeks ago, I was expecting to hear Elle talk about the use of equity, which he tried to do a couple of times, but we had that other gentleman on there who kept telling us about his experiences in multiple counties and how much money he spent, and I didn't really appreciate him wasting everybody else's time when we could have gotten something from the first hour about how to actually put this into implementation. And that's why I was trying to raise my hand to say something, because I thought it was about time that the speaker take over the call rather than someone that was just coming on the call. We all have war stories. I can tell you 100 war stories, but I don't know how that's going to move us forward.
Well, we all know that our own story is the most important one, right?
Right.
So, Elle, did you want to, and I'll mute you back up. Elle, did you want to go into exclusive equity?
Yeah, I could talk about it a little bit. Okay, so the best way for someone, if they actually want to learn how to actually implement it, to take action, is to get the book, A Treatise on Suits and Chancery. It's a how-to book, okay? And as you read through the book, you'll realize that the jurisprudence transformed prior to the Emergency Banking Act. And if you know about the Emergency Banking Act, and what you can do is you can read the different kinds of suits that equity can adjudicate based on rights, right? Claims. And then and it's great because there's actually templates there. And that's the cool thing about equity that I've learned, is that it isn't like the Roman equity that's very technical and very procedure, and that they don't care about the substance, they care more about the form. And so, like one of the ones that most people go into with exclusive equity is that it's a private trust. And so the courts that are out here do not have the right to adjudicate on private trusts. And that has to do with how you present your paperwork, whether you're sending it directly to the judge or if you're going through the clerk. Because typically a clerk will look at it and say, okay, this case is for family, this one's for this. And so really you have to know kind of what rights you're claiming, and then you can draw up your petition or your bill based on your rights. Mm-hmm. So that's the one that I know that most people go in with, is a private trust. Was that good enough, or?
Well, hopefully that was a decent enough explanation. And I'll tell people as well, I mean, I have people all the time contact me, and they're like, well, we'll just say exclusive equity, for instance. They're like, what does this mean? What's that about, or whatever? And I kind of laugh to myself. I think, you want me to do the legwork? I mean, you can go to the Great Oracle, whoever you may use, Bing, DuckDuckGo, Google, whatever, and you can type that in, and you'll find stuff that comes up. I even recommend to people if you're going on Google, go over to Google Scholar, and it will bring up like cases where the term exclusive equity is referred to, and that's a very simple place of learning things from. Let me jump over and see who else had a hand raised. I know there was AOUCE, Aus, if that's how you pronounce it, that had a hand raised, but they also have a caution sign, so I don't know if that means they're having a problem with connection or what that means.
Hey,
but they are unmuted. Hey, how you doing?
Yeah, so you said earlier, Elle, that with equity I can go back and correct mistakes from the past. Like, does that... If that's so, how is it, and does it include statute of limitations if it's longer than 2 years or whatever?
Okay. Hi, first of all. So the statute of limitations is at law, okay, which is different than equity. See, equity sees that as done which ought to be done. So what it does is it looks at like when the issue actually arose and what should have actually happened from the time that like the mistake, accident, or whatever fraud happened, and it puts the parties back where they were supposed to be there. And that's how they do it. You know, they literally just look at it. Like, for example, say someone stole my car, okay, and it was mine. I have the right to it, and I didn't know anything about equity proceedings, and I'm still learning too. But like, and so you're telling me that I can't go back after 3 years? Well, equity wouldn't allow that to happen because that's not what's fair, right, and just. You know, they're going to go back and be like, correct it. And that's kind of also, I think, the maximum equity is the law, follows the law, like where the law can't give an actual fair, right, and just remedy. That's where equity steps in, and it goes back in time. It's beautiful, actually. It's like, you know, you ever notice how, like, if you read the scriptures and it says, if my people will repent and if they will just come to my throne and to admit their trespasses against my law and their ancestors' trespasses, that I'll forgive them up to 1,000 generations. 1,000.
Oh, as far as like statute of limitations go, though, as well, that even still spills over into equity as well, because the doctrine of lashes is part of equity. That's an equitable arrangement there as well. Whereas the doctrine of lashes says, well, you learned 5 years ago that this or that was done to you, and you know, have you exhausted your resources as far as correcting the matter and making it right or not? And under the doctrine of lashes, if they see that no, you've basically just sat back and let whatever happened go, then they're going to say, well, you accepted it. I mean, that kind of falls under the idea of tacit agreement, that you didn't bring it up. And so, I mean, and that's kind of where they say, if it's not raised, it's laid. Which if you don't bring up the problem, then they're just going to roll right over it and assume that everybody's in agreement.
Right. And so that would be waiver and consent. But here's the thing. Ignorance of your equitable rights is forgivable. And no one, for example, if someone doesn't, like the man who was speaking earlier, if you don't know what to do, that's an impossibility. That's not fair, right, and just. They're not going to. What the doctrine of latches is sometimes people will just sit back and know what to do, but it benefits them to wait. And so they'll just wait and let all this BS stuff happen. And then they'll say, no, you can't. That's the doctrine of latches. You can't just let all this terrible stuff happen so that you can benefit from it later. But if people don't know how to actually say, hey, wait a second, I'm still learning this, right? Like, what are my equitable rights here? And if I don't know how to move forward and bring a bill or bring a petition, then they're not going to apply the doctrine of latches because that's not fair. But if you're trying to buy time to benefit yourself, then yeah, they're going to be like, no, I can see that BS a mile away.
Well, one of the main points though with the doctrine of latches is that it doesn't matter that something, say, for instance, happened 10 years ago and you didn't do anything about it. What matters is when did you learn that there was something you could be done or that what happened actually was wrong and you should do something about it. I mean, that's going to move the timeline from the event, say, 10 years ago, up to the point where you discovered the situation. And then that's really what the doctrine of latches is identifying. They're not going to say that just because it was 10 years ago means that, oh, you've consented. No, where the doctrine of latches looks at is when did you learn of what was being done as being incorrect and that there was remedy for it that you could utilize. When did you find that out? Because that resets the timeline.
Yeah, and when did you have the actual knowledge to actually be able to act on it? Because we can't be expected to do an impossibility. You know what I'm saying?
Right.
This is just what's fair. This is how our Creator is. He's not going to send us off into a bunch of battles to stand up for rights if we don't know how to do it. Now we will be disciplined though, so that we'll wake up. But that was a good question. I like that one. It's pretty cool, isn't it? Isn't it cool? Right. I love it. I'm like, dude, we could go back and fix all these mistakes, starting with ourselves.
With so many of these things, even with the doctrine of latches, it all goes back to the backbone of so much of this, which is intent. What was the intent? The mens rea. Everything is about intent.
Yeah, that's one of the reasons why equity it really wants things written on paper, so that if it has to be adjudicated, that they can actually try to, say someone's there's a controversy, so that they can actually get to the intent, the will, if you will, of the parties and what their intentions were. And, that's unfortunate because, at least for me, walking around not realizing that I'm out here in the UCC and blank endorsements and not knowing about trust, it's the intent is that she's completely ignorant. There was no, and that's when you get into implied, right? You get into implied trust, that which is expressed extinguishes that which is implied. So we can go back and correct that stuff, which is beautiful. I mean, it's beautiful that our Creator is so gracious with us, I made a mistake, I'm sorry.
Well, let's play around with that idea a little bit there, because we know that in court proceedings, that's exactly what is normally being used, is an implied trust is being put in place. And so if you express your standing regarding this implied trust, like you said, it's going to extinguish that situation. And they're going to actually have to vocalize exactly what's happening here and the action that's being brought forward, what's going on. It's not going to be a matter anymore of, well, you should have known that this is what was going on. No, it needs to be expressed by them.
Hmm. Well, that's the thing. In the open courts, they won't do that because they have to maintain public order. But just real quick, if I can, Brian. So we use the word mistake a lot, right? Like, oh, I made a mistake. I'm sorry. Forgive me. I do. I use that word because I make a lot of mistakes. And it was very interesting, and I want to thank Keith for this, Brother Keith. I started realizing that there's different. We're talking about a form of law or equity, something that's rolling over, a realm, a jurisprudence, if you will. That the idea of a mistake, there's different kinds of mistake. It's actually a concept. It's a lawful concept. It's not just words that we use. So if anyone, if you want to learn about a mistake, you got to actually read about what it means when you're bringing something, like, say, I hear a lot of people talk about rescission, right? Based on, this is unconscionable, no reasonable man would do this. Well, that's really cool. Like, for example, when I read about, we talked about this before, Brian, about voter registration, right? Well, little did I know that that's like handing over all these rights and putting the estate in abeyance and basically giving over my power. So it's an equitable doctrine. You have to give someone notice before you can bring an action against them. We're not allowed to ambush people. But I didn't know, because it's all financial, right, in the background, that it's courts that, equity courts that adjudicate and will correct all those financial aspects that are running in the background. Maybe some people do know about it, based on mistakes or accident or fraud. And so there's more to it than just giving a notice of a rescission, because the whole point is to not, not to owe any man or have any man owe us, just to keep it even, zero,
Right. Well, even with a point of rescission, and there's a particular situation, I'm not going to bring it up. I think a lot of people probably know about it, and I'm not going to identify it. But if somebody leaves or they exit and they say, hey, you guys go your way, I'm going my way, I won't come against you, you don't come against me. I've seen situations like that where people had that agreement, but then again, a year or two later, they decide, oh, I'm going to go back in and sue them for this and sue them for that. That's not something that really can be done. And I guess the main point is that with a situation of rescission is that your actions have to follow up with the decision of rescission that had been made. And everything that's going to be looked at, they look at actions. Because so many times, even we enter into contracts just through our actions. We're accepting things without really even stopping to think about it.
Mm-hmm.
It goes back, go back. Faith without works is dead, right?
Yeah, that's funny because actions, what, now you're talking about causes of actions, right? And that's the interesting part when I started studying trust, is that a lot of people, it isn't just intent, it's the manifestation of your intention. I could be like, well, I plan on being a Bugs Bunny, but what am I going to do to manifest that intention, or like, it's the actual outward action and expression. And again, we're supposed to be a royal priesthood. That's what we're supposed to do. I mean, maybe not everyone, but, and the priest works with biblical law. So like for the gentleman who asked earlier, it's funny, the statute, okay, now we're back at statutes, which aren't law. Statute of limitation, it's a statute. And what I can see in the Bible when I read, because when I learned about idem sonans, when I read it and I hear it, it's like, wait a second, when I bring you into your land of inheritance, tear down the statutes. And I'm pretty sure you don't mean like the marble things that are outside, right? Because everything's based on law form. Tear down the statutes. Anyway, just thought I'd share that.
Well, I was just kind of scrolling through the board, too, and looking through the chat to see if there's any questions. And It looks like in that first hour we had a whole lot of people drop off. Sorry about that, people. Just a strange technical issue. You have to realize that where this is being broadcast from is pretty much where the eye of Hurricane Ian hit. And when a hurricane comes through, you don't just sweep up the streets and start over a couple days later like nothing happened. I mean, there's a lot of infrastructure damage that they've had to put up, temporary cell phone towers and things like that, which they're constantly doing work on. So that's probably what happened this evening as far as the internet connection went. I ended up having to go and connect through 3 different sources. And I had to connect to a source to run the board. I had to connect with another source for audio, and even being able to get onto the TalkShoe link as well required an additional source. So sorry about that, everybody.
I appreciate your effort. So there aren't any more questions? No one has any questions? I have a ton of questions.
I don't see hands raised, and I'll go and take a second glimpse over here at the chat room and see if somebody pops something in there, which was fairly active. Lex threw a link in there that people can take a look at.
Hey, Lex. Thanks, buddy.
But I find it interesting, you know, I've got people that share links with me all the time to different calls that people do. And I sit, and sometimes it's painful to sit and listen to a lot of things about too many.
Well, Lex probably dropped a link to a bunch of equity books, if I know him. Can you hear me, Brian?
Yeah.
Yes. So is it a mega link? So, yeah, we collected quite a library of dictionaries and equity books. So if you did that, Lex, thanks. You're awesome.
Yep. And recommend people go and check that out. But like I was saying, you know, there's so many things that get thrown around and so many concepts that get thrown around that are just completely false, you know. And I've even asked about some of these things before because I'll see them, you know, on a thread talking about things. And where do you get that from? Where did you back that up at? I mean, one of my favorite questions is, who told you that? You know what I mean? And whoever told you that, where did they learn it from? You know, where's the source material at? And I think probably one of the most popular ones I hear tossed around, which I guess this is a big thank you to Jordan Maxwell, was people referring to the British Accredited Registry or the British Accreditation Registry, or however the different ways are people term it, which is completely bogus. There is no such thing. And anywhere that if the word bar is an acronym, it's going to be in all capitals. And other than people's personal message boards, you don't see it anywhere in all capitals as BAR. If it might start out a sentence with a capital B, then AR. Otherwise, it's all just really lowercase BAR. It doesn't stand for any type of nefarious organization or anything like that. And I think if people can get past those, I call those surface level fluff things that cloud your view, we get past that crap and dig into the truth, for instance, like what we're discussing, what equity is, and see how things are really running in the background, you'll have more actionable information. You'll have things, something you can actually do something with that won't get you laughed out of a courtroom.
Well, it used to be, Brian, that, and still today, if you go to the American Bar Association, you can look up, they have at least the 19 equity maxims there. Because it used to be that it would just be like if someone brought a suit, it was man against man, or if you, that was one court, right? There was a common law court, and then there was the equity court, and then there was a statutory court for corporations. But, yeah, you can go to the American Bar Association and actually look that up. It's there. Because at one point, though, so many people became incompetent to handle their estates and their family affairs, and getting claimed by other trust companies, that they had to they went from solicitors to hiring people to come in to adjudicate for people because people failed to learn how to bring their own suits. And that's an interesting one, that for a long time I was like, well, what's the difference between a solicitor and an attorney and a lawyer too, and that's worth looking into for people, as well.
Yeah. And you might even want to get one of those little signs to put in front of your house that say no solicitation.
Well, what's funny is in the Bible, it says that the wealth of the wicked, now let's define wicked based on what the Bible says. And the Bible says that it's those who aren't doing the biblical law. That's what wicked is. That's anyone who's not doing that, right? That the wealth of the wicked is stored up for the righteous, and righteous is synonymous with equitable.
Well, there you go.
So,
look at the word wicked, and what I really appreciate in researching a lot of these things is learning things from people who actually go to source words. Go back to the original. And if you're looking at scripture and you're seeing the word wicked, we know that word gets sourced from witchcraft. And you go deeper and you look at what witchcraft really is, what is being referred to in scripture. And witchcraft is for you to goad somebody or to push somebody into doing something that they otherwise would not normally do. That is considered witchcraft. And so I think that's probably a good reason why we see a lot of men refer to their exes as witches, because they got them to do things they normally wouldn't otherwise have done. But this
that goes both ways.
Yeah, as I say, this doesn't only pertain to females. The males do the same thing. There's narcissism behavior on both sides. So anytime somebody is being forced into doing something that they naturally wouldn't otherwise do, that's really the definition of witchcraft, and that's what being wicked really is.
Yeah, going against someone's will. But most people, for me, I'll just talk about me because I can't speak for other people really, but I have observed this, is what is a will? Because, in the Bible it says over and over again, the Messiah said, I'm here to do the will of my Father. And so when I first, because I said this a million times, I wasn't raised in a church, so I didn't have this. So I joined all these groups, and I kept saying, what's the Father's will? What's the Father's will, right? And then I started learning about wills and testamentary trust and all the different kinds of wills. And if you die intestate, that the person's will isn't expressed. And that's an important part of this as well, is to realize that, property rights, where do they come from? Are they coming from the Creator? Are they coming from where do they come from? And based on that, then what rights do we have to claim based on where we align ourselves with, which law form? So that's one of the things that I really hope that people take the time to ask these questions, because for me, as I study scriptures more, I just love the Bible so much because I don't have that indoctrination. It's so cool, man. It's like high-tech devices. You got crystals, essential oils. There's there's so much to it, but it's like a law book, witnesses. Where does that come from? And all of the laws, if you study them, involuntary manslaughter, murder, perjury, perverting justice, bribes, it's all in there. It's in the actual Bible. It's very extensive too, right? The rights, because biblically, just like with equity, it deals with property rights, because you had the priests who were like the real physicians that worked with salts and clays and oils and stuff, and you had the the people who were adjudicating, if they were like adjudicating that law. And so the other tribes that weren't, working at the courthouse, the temple, if you will, they were out like, raising sheep or blacksmithing and stuff. And so what happened as a community, in order to support the people that were working at the courthouse or the temple, they would bring they would bring like whatever they were creating, the first fruits, and they would dedicate it to the temple to support it, because at that time, I so am looking forward to the next creation where I can actually know this stuff, right? To create it, to live in an actual community that comprehends biblical law, because the more I've studied it, particularly when you add in matters of mistake and grace, right? Like someone legitimately makes a mistake or there's an accident. That's another big one people should read about, accident, what that means. That there's mercy there. And over again, that's where you get when he would always say, I don't want these sacrifices. I want people to be obedient. Teach them. You guys just, all you care about is getting rich and the power. And they stopped teaching people. My family, whoever they were, like my ancestors, lost the way of what real true law is. And this continent, the jurisprudence was based on the Bible. It was common law. Biblical.
You get into Scripture, and you look at Scripture, and you're talking about, the will of the Father. And if we want to know what the will of the Father is, and you bring up property, which, side note, we all know is not real estate. We're talking about property. There's a lot of things that are property. Even your rights are your property. But go into the very beginning, and you go into Genesis, and you can find out what the will of the Father is. If people want, why am I here? What am I supposed to do? Well, it lays it right out there. And a lot of people will push back against, like, the use of Scripture, the use of the Bible, and say, this was written by man in, say, 1611, or whatever the case may be. And I'd recommend going to our WordPress site, and I've got an article there that lays out the chronology of the Bible, where it all really came from. And one of the things I find frustrating is I'll hear somebody pull out a verse from Deuteronomy or Revelation saying that nothing in this book is supposed to be changed, and they don't realize that book, and they see the word book, they think it's talking about the Bible. No, it's talking about that book of Deuteronomy or that letter of Revelation to the churches. It's talking about that writing specifically. Those things were never compiled together at that time into an entry. It's not like somebody wrote a book and said, okay, this will be the next book. Well, now let's work on the fifth one or the sixth one. It didn't work out that way. But if you look at Genesis and look at what was the will of the Father, what did he tell Adam to do or Eve to do, if they were real entities, the way they were being presented? Well, they were told they were to take care of the earth. They were make sure the earth functioned the way it was supposed to function, and they were supposed to procreate. They were supposed to replenish the earth. And other than that, there wasn't a whole great big list of laws and rules and do's and don'ts necessarily set out for them.
There could have been, but it's not chronicled, right? So
we only know what's there.
Yeah, we do know that they were told, like, over here, and there's no details, right? It doesn't go into details. But over here, you're going to have a very prosperous, you're going to live in harmony with me if you eat from this tree, which is basically a jurisprudence of governing laws that the Creator gave them. And then over here, you'll be like, you'll know about God, which is basically adjudicating what's right and wrong. And so they chose to do that. And that's what's really cool about when you get further down into the book of Leviticus and you get into Deuteronomy. I figured out that the will is for me to actually live in action what it says to do, like the food laws, the sex laws. And I just think it's crazy when you go back and you read about them, at least for me, because you know this, we did a call before about parasites and stuff, that like back then, I don't know, maybe they did know that all that food that he designed the animals to clean up the rubbish off of the ocean floor and the air and the ground, they're riddled with parasites and mycotoxins and stuff. And we're not supposed to eat them because, you know, we're supposed to try to keep our temples holy. Same with the sex laws. I mean, if you read the sex laws, it's like, man, did they actually really need to write all this down? Well, apparently they did.
Hey, I don't know.
Yeah.
I don't know how much time I'm really going to have right here where I'm at, but I see Lex has his hand up. And so jump over here to Lex and open his mic up for him. How you doing, Lex?
I'm all right. Yourself? Can you hear me? Hello?
Yeah, you're a little faint.
Oh.
Hey, Lex.
Hey, Lori. How are you? Let me see if I can...
Good. I'm glad you showed up.
Darn it. I didn't think my mic was that low. Let me see. Input.
It's better now, Lex.
Is that a little better?
Yeah, it's a little better. Yeah.
Okay.
Yes.
Good.
Well, I mean, we were talking about equity and, you know, how it's different than law. And I think, you know, people could benefit from describing how, let's say, a typical case would, you know, we know how it's playing out in the courts, the typical outlaw courts, versus how it could play out in equity. For example, and correct me if I'm wrong, Lori, let's say, you know, your typical, let's say, mortgage foreclosure, it's going through the courts. Bank of America has an army of lawyers out there, like a swarm of locusts, you know, basically trying to grab everyone's houses, right? And these outlaw courts, they basically see they don't really see the people, they just see the fictions, the corporations, the banks, and all that. Whereas, if I'm correct, let's say if you raised an issue of substantive property rights and you got into chambers in regards to, you know, Bank of America trying to grab your house, if I'm correct in exclusive equity, because, right, Lori, you know, equity acts in personam. So if my understanding is correct, you get into chambers, the CEO of Bank of America himself would have to come in and answer for what they're doing, right?
Well, kind of. Mortgages are interesting because they're actually executory contracts. And you're right, because what they're doing is they're claiming both the legal and the equitable right. Mm-hmm. So in chambers exclusively, particularly with a mortgage, because equity, it doesn't happen a lot because not a lot of people know how to do it, but it does. It acts in personam. And they don't get, because the equity abhors a forfeiture, and so they don't get to keep the note and get the property. That's just not equitable.
Right.
Yeah. So and so what they do so what equity does then, so the man has their person, right? Mm-hmm. So then what equity does is, instead of like doing a writ of execution and having the sheriff go and sell his property, equity would force the man or the woman who, you know, is responsible to do it themselves. And if they failed to comply, then they would be sent to jail until they were willing to comply, because it forces people to act on their own conscience instead of necessarily their property.
Okay.
All right, did you have something you wanted to add, Lex?
Yeah, I was just thinking that maybe that the just, you know, compare and contrast the differences. Like I had the idea that, okay, maybe the CEO of Bank of America, depending on exactly what you're bringing forth and, you know, what the chancellor sees, that he may hold the CEO of Bank of America himself personally responsible for having to correct, like, your situation. And even though the CEO may come into chambers with his lawyer, my understanding is correct, the chancellor may very well ignore pretty much most everything that the lawyer says. You know, listen to him politely, but say, yeah, whatever. And just, you know, because the chancellor is going to see the CEO. He's not going to, basically, equity can see through the veil, the corporate fiction and all that, and it's going to look at the people doing whatever, right?
Yeah. Yeah, that's pretty much one of the presumptions, is that true equity does realize that most of what's happening out here is a bunch of lies, deceit, and fraud. And so they're not going to give voices. They're not going to, they might allow someone to attend, but they're not going to give a voice to someone whose actions and deeds have been, they haven't been equitable, and they're operating off of fraud and stuff. Mm-hmm.
All right, Lori, we had Angelo Swift is on here also with a hand up. And so we'll unmute Angelo. How are you doing, Angelo?
Good, thank you, sir. Just questioning how to establish a court of equity. How do we know what court we're in? And it seems to me we have to establish that, or have to, with our pleadings, let them know that we're coming.
Yeah, so it is basically based on, because we bring our court, right? We're bringing it if you're making a claim. So it's going to depend on how you're bringing up, if you're doing a bill or a petition. And then you're going to want to present it, depending on how you want to move. You're going to have to you're going to have to find which court to go to, right? Because courts do have auxiliary. They do run concurrent, but you have to know how to present it. And sometimes it's in camera privately, and that takes that. In order to find the courts that adjudicate equitable matters, you can go to the state constitution and chase it down to figure out which court it is. That's how you find it. And then you figure out what your cause of action is, like which rights have been trespassed. And then you would set up your petition or your bill based on the essential elements that are needed and present it.
And look at the causes of action that are inequity, and take a look at some of those and see what fits as well, because then you can bring forward your court in one of those causes which are equitable.
Yeah, that's in a treatise on suits and chancery, the 33 children of equity. It enumerates them.
Well, tonight didn't go quite as smooth as normal. We had our own little technical issues, which does occur, thankfully, very, very rarely. But I hope this answered a few questions for people this evening. And next week, I'm hoping that things are lining up correctly to bring on a guest that I'm very sure everybody on this call will know the name of, from a very, very, very huge YouTube channel, and we'll see what happens with him. And hopefully things go a little smoother next week. I always try to remind everybody every week also, probably one of the most equitable things you could do is you need to learn who you really are, where you're really from, and where you're really at. Because that will unravel a lot of mysteries to you and really open the door for you to truly operate in equity. Thanks for being here tonight, Lori.
Thanks for having me, Brian, and thanks for my friends for showing up to support. Appreciate it. May you all be blessed.
Yep. And we'll do this again here in several weeks, where maybe it'll be a little smoother. But, hey, this is life. I mean, this just shows you that this isn't like any type of psyop or controlled opposition or anything. But we're real people trying to use the technologies that have been provided, and they always don't work out the best. But, hey, it is what it is. Thanks, everybody, for being here, and look forward to seeing you in the future.
Good night, Brian.
Good night.